Welcome. We're going to go through question 1 from the 2018 February bar exam, most notably because so many students had trouble with this question. Out of the 5 essays, this was the one that was the toughest according to most applicants, so let's just take a look at it and dispel the myth that it's difficult. Okay, let's take a look at call number 1. Now, a lot of people will tell you you have to spot the issues on California bar exam, issue spotting, and I laugh every time I hear that because the exam's really not about issue spotting. It's about applying the law correctly. I'll prove it. Will Beverly be able to rescind? That means cancel. Rescission is canceling the contract, undoing it and starting from like it never happened, so we cancel the whole transaction. Is Beverly able to rescind the contract with Austin on the basis of misrepresentation and or non-disclosure? Don't look now, but the examiners just gave you the issues they wanted you to discuss. Okay, so Beverly, contract with Austin. And you always go to the call the question first because now you know what to focus on. Rescission, misrepresentation, and non-disclosure. And I know from just experience and just from knowing the law, you can obtain rescission extremely easily for contracts. In fact, even an innocent misrepresentation can be the basis for rescission as long as it's material. So if I tell you that I'm selling you a car and you ask me, is that the correct mileage? And I say, yes, 68,000 is the correct mileage. And I honestly believe it is, but it turns out the previous owner cracked the odometer and sent it back, and I didn't know that, so I made an innocent misrepresentation. You can still obtain rescission because that's material, because the average person would want to know about that before purchasing the automobile. So rescission is incredibly easy to obtain. So we have rescission, which we say is canceling the contract, and it's very easy to obtain for contracts. Unlike fraud for torts, the tort of fraud, the tort of deceit, you need an intentional misleading statement, something intentionally done, and there has to be actual damages. But we're not getting into that. Ironically, in case you don't realize this, when I say the examiners tend to repeat themselves over and over again, this is the third bar in the row. Third bar in a row, the examiners tested fraud. Believe that. And fraud and misrepresentation are one of the same, just FYI. So we have rescission, we have misrep, and non-disclosure. Doesn't seem that difficult to me right now. And then call number 2, what ethical violations has Lou discussed? Lou, PR. Okay, let's take it from the top. And one of the things you're going to notice is the way that they write these essays, and if you actually looked at the whole examination process, the way that the State Bar does it, they want to test certain issues in each essay. So the way they write it is very segmented. If you notice, call number 1 paragraph number 1 goes to call number 1. The final paragraph goes to call number 2. So it's not really one essay, it's actually looks like this. So as you can see, the first paragraph goes specifically to call 1. The last paragraph goes specifically to call 2. Now that middle paragraph is actually just a recap of the call to question in call 1, so it's the same thing. So if you look at how the examiners separate it, it makes this exam much easier. And we're going to also notice that in the rest of the essays, question number 3, they do that. Paragraph 1 goes to 1, paragraph 2 goes to paragraph 2, paragraph 3 goes to paragraph 3. We'll discuss that in just a minute when we do the next essay. Okay. Taking it from the top. Austin recently sold a warehouse to Beverly. The warehouse roof is made of a synthetic material called top tile. Now this contract involves the sale of commercial property, not residential property, which is, I'm not quite sure the examiners were looking for this, but according to Preel's Hornbook on Contracts, 7th edition, that the as-is clause and caveat emptor still actually applies to commercial property, whereas it doesn't apply to residential. That's a whole other issue I'm probably not going to get into until the examiners release the actual answer they were looking for. During negotiations, Beverly asked if the roof was in good condition, and Austin replied, "I've never had a problem with it." Well, that statement is true, but it's only partially true, which means it's misleading, because as we find out in the next sentence, in fact, the manufacturer of top tile notified Austin last year that the warehouse roof would soon develop leaks. So, although Austin has never had a problem with it, and that might be truthful, The fact that he's not disclosing the rest of the information makes the statement a partial or half-truth, and it's misleading because without those additional facts, it implies that the roof is completely fine, when it's not, because you're eventually going to have problems with it. And a half-truth can be the basis for a misrepresentation. So rescission, to cancel. And that's just the remedy, so we don't really have to go into a big discussion with that. But a misrepresentation is when somebody misleads you. It has to be material or fraudulent. Fraudulent means intentional. And here we have a half-truth. And a half-truth is just as misleading as an intentional false statement. So a half-truth is a statement that is misleading unless additional facts are disclosed. So Austin's lack of a full disclosure here constitutes a misrepresentation. So continuing on, the valid written contract. When the examiners say valid written contract, that's their way of saying do not discuss formation, do not discuss statute of frauds, and that if you waste your time discussing those issues, you're actually just going to waste time. You're not going to get points, as some amateurs might claim, like just throw everything in there, you're going to get points. There's nothing can be further from the truth. If that was the case, why not just discuss everything you know about contracts? Why would there even be a fact pattern? Think logically, people. When somebody tells you that, question what you're hearing. I'm telling you exactly what the examiners are looking for and why you need to get it done in an hour. If you don't get an essay done in an hour, it's because you're spending time on irrelevant information and irrelevant immaterial issues, which here would be statute of frauds, which would be formation with offer, acceptance, consideration. You went into that, you just wasted time, and a grader's not even going to read it. There's no point. There's nothing you could possibly say that's going to affect my decision on whether or not what grade you're going to be. Question is, did you apply the law correctly based on the facts that are given and the issues that are presented? It's that simple. Don't make this exam to be tougher than it is. It's really not. The valid written contract to sell the warehouse specified that the property was being sold as is, with no warranties as to the condition of the structure. As is. Well, oftentimes you will think about if you're at a car lot and you're going to buy a used car and it says it's going to be sold as is. Well, just because they're selling the car as is does not give them the right to mislead, commit fraud, or make an intentional misrepresentation. So an as-is clause is valid, but it will not prevent a party from proving fraud or misrepresentation. So the as-is clause in this example has no weight and it has no validity in terms of the fact that he told her a half-truth. Okay, so that's what's going on there, the half-truth. So an as-is clause does not prevent a party from proving fraud. Fraud corrupts everything it touches. Even when in real property, when you accept a quit claim deed or even a warranty deed, and they didn't tell you about the termite damage, you can still rescind the transaction even though the doctrine of merger says you can only sue on the deed, not on the contract. Because the contract was fraudulent, it's called void ab initio. That means from the beginning, so you can go back and rescind it. Like I said, rescission is really easy to obtain for any type of fraud or misrepresentation. Now, with the non-disclosure, the question is, does Austin have a duty to disclose the condition of the property? Well, if a seller of real property knows of any facts materially affecting the value or desirability of the property, and also knows that such facts cannot reasonably be known or ascertained by the buyer, the seller is under a duty to disclose that. So in other words, a seller of real property has a duty to disclose hidden defects that cannot reasonably be discovered from a simple examination of the property. So Austin might have had a duty to disclose the condition of the property. If it was residential, Austin would definitely have a duty to disclose. But this is commercial, and I don't know if the examiners are getting at the fact that caveat emptor still applies. It's such a slight hornbook distinction, I can't imagine that the examiners were looking for that, although they do use the word warehouse 6 times in the fact pattern. Count it, it's 6. Okay, so non-disclosure, do you have a duty to disclose? Latent defects. Conclusion, I think, is immaterial. The discussion and the way you analyze it is more important than whether or not you say they have a duty, like Austin had a duty to disclose. So that's what's all going on number 1. And look at the second paragraph. After Beverly bought the warehouse, the roof immediately started leaking. We knew that was going to happen. Obviously, the examiners need to, finish the story. Beverly hired Lou, an experienced trial lawyer, and I can't imagine why that actually factors in, because the examiners usually don't use descriptive language without a reason, and executed a valid retainer agreement. Again, valid retainer agreement. Do not discuss the reasonableness of the fees or contingency fees or any type of whether it has to be in writing or whether it can be oral in California if it's a corporation, under $1,000, etc., etc. Beverly then sued Austin for rescission of the warehouse sale contract on the basis of misrepresentation and non-disclosure. So in case you missed the call of the question, they give you the issues one more time. Misrepresentation, non-disclosure. Half-truth, as is. As this clause has no bearing, it's a half-truth because it is misleading. That's the same thing as fraud, so misrepresentation. They'll be able to obtain rescission of the contract and non-disclosure. Question is, do they have a duty to disclose? Because this leaky roof will not be ascertainable by the buyer. That's, again, the conclusion is somewhat irrelevant. All right, so moving on to the PR issue, number 2. And notice that the last paragraph goes directly to call to. Lou offered the expert testimony of Dr. Kress, a chemical engineer, who had testified in other litigation concerning top tile roofs. Lou knew that Dr. Kress had previously testified that the roofs always last at least 5 years. Okay, don't forget, a lawyer in trial must not knowingly offer false evidence, which includes false testimony. But hold on, the lawyer also should resolve all doubts in favor of the client. We're not there yet, but I'm just bringing that issue to the surface so that you understand where we're going. Lou also knew from the manufacturer's specs that the roofs seemed to last for an uncertain period of time indefinitely, but not in some climates. Across examination, the expert testified that the roofs never last 5 years. Whoa. So this expert, Dr. Kress, at one time, previously testifying in other trials, said they always last 5 years. Now he's saying he never lasts 5 years. And as the lawyer ends up repeating that statement in closing. The question is the lawyer presenting false evidence? Now most people will be like, yeah, you're lying. I think the better analysis, duty, false evidence, and that has to do with candor to the court, fairness to the other party. Okay. I think a strong argument can be made that Lou does not know whether or not the doctor is lying. Because I think it's fair to say the doctor might have changed his opinion. It's possible. I mean, if you ever think about it, have you ever been in a relationship with somebody, and when you first meet that person, you say how great that person is, and you guys break up, and you tell all your friends how terrible that person is? What's changed? Your opinion has changed. Doesn't mean you were lying before, doesn't mean you're lying now. It means that you one time thought this, and one time and now think that. So I'm just saying, it's an argument, it's a discussion I think that could have been made. Of course, when the examiners release both sample answers, I'm curious to know if they actually make that, if they actually have that discussion, which I have a feeling one of them will. Okay, so again, person has the right to change his mind, so does Lou really know whether or not the doctor is lying? Okay. So on cross-examination, the doctor testified that they never last 5 years and climate is not a factor, although the manufacturer specs say it is. So, I mean, that doesn't seem to be honest testimony, so you could probably get the line right there. Top tile roofs fail within 5 years everywhere in the world. That may or may not be true. Again, we don't know. I mean, you're not an expert in this. I'm not an expert in roofs. As a lawyer, Lou's not an expert in roofs. Lou knows what he's read. I mean, it wouldn't be the first time the manufacturer's specs weren't honest. So Lou has, and don't forget, a lawyer has to resolve all doubts in favor of the client. So we have that whole dichotomy between presenting false evidence and resolving doubts in favor of the client. However you want to discuss it is fine. I'm just saying I think there's a discussion there. During closing arguments, Lou repeated the statement, and if it's false, then he shouldn't be repeating the statement, and that's where the ethical issues come in. And also said that Lou's own inspection of the roof confirmed Dr. Kress' testimony. Now, this is similar to a lawyer being a witness, but in trial, a lawyer must not assert personal knowledge of facts in issue except when testifying as a witness. So the lawyer cannot say, hey, my own observations, because the lawyer is asserting his own personal knowledge and he's not testifying as a witness. He's acting as counsel in this trial. So that is completely improper. It's actually, if you want to look up the rule, it is Rule 3.4E. In trial, a lawyer may not assert personal knowledge of facts in issue except when testifying as a witness. ABA Model Rule 3.4E. California does have a similar rule as well. So let's do a recap really quick because we pretty much finished off the essay. For call number 1, with rescission, they're going to be able to, Beverly's going to be able to get rescission because of the misrepresentation. So she'll be able to cancel the contract. She'll get her money back. Austin will end up getting the warehouse back with the bad roof. Of course, she can always sue for damages, but she's not. She's suing for rescission. The misrepresentation. We have a half-truth, and a half-truth which is partially true. It's misleading unless additional facts are disclosed. Can be the basis of a misrepresentation. The as-is clause, while as-is clauses are valid, they do not protect a party from committing fraud. So you can't slap an as-is clause on a misrepresentation and escape liability. It doesn't work like that, so it has no validity under these facts. The non-disclosure, whether or not they have, Austin had a duty to disclose, because this was commercial, not residential. But generally, sellers of real property have a duty to disclose any hidden defects or any kind of defects that the buyer may not reasonably discover. You have a duty to disclose. Duty to falsify evidence, can't enter the court unless provided the fairness to the other party. Did the lawyer really know it's false? Did Lou really know the doctor was lying? We don't know. And the final thing was the lawyer as a witness. And the lawyer may not assert personal knowledge in trial unless testifying as a witness. At least do a fact and issue, obviously. And that's it. That's a wrap of question 1 from 2008, February. Question 1, contracts and PR. Hopefully you understood this and it made sense. And in the future, if you have to take the bar exam, make it easy on yourself. The examiners try to do it, so make it easy on yourself. Take it easy.